The principal display panel of every packaged commodities must include all the mandatory declarations outlined in the legal metrology, packaged commodities rules, mindsync offers, product labeling guidance, and compliances for your packaged commodities. Contact mindsync today.
Digital India has resulted in the digitization of the Indian economy. Presently, there are over 76 crore active internet users, and over the next coming years, this is expected to touch 120 crore. Hello, and welcome to MindSync, your compliance guard. I am Swati from MindSync. On November 18, 2022, Ministry of Electronics and Information Technology introduced the Digital Personal Data Protection Bill 2022, with an objective of providing regulation around digital personal data. The bill emphasizes individuals' rights and privacy principles in a simplified manner. Following the cancellation of the previous bill of 2021, the current bill was released for suggestions. MindSync has come up with a brief video on the currently released Digital Personal Data Protection Bill. Ministry of Electronics and Information Technology regulates matters relating to information technology, electronics, and internet. The ministry provides assistance to other departments in the promotion of e-governance, e-commerce, e-medicine, e-infrastructure, etc. What's new in the 2022 bill? Let's know. Protecting digital personal data only. The bill governs digital personal data, which means information that can identify a person and is either collected online or is digitized. Non-personal data and non-digital data are excluded. The 2022 bill recognizes the concept of deemed consent. An individual is deemed to have given consent when the individual provides her or his personal data voluntarily or for employment purposes, or where it is required for the performance of any function under any law. Cross-border transfer of personal data. The 2022 bill envisages that central government may notify the jurisdictions outside India where personal data may be transferred. Permitting data localization requirements. Data localization is storing critical and non-critical data within the territorial boundaries of the country. This has been done away with in this bill. Certain duties has been affixed on data principle, which include complying with applicable laws while exercising rights. This has been explained in depth in the further slides. Instead of the Data Protection Authority of India under the 2019 bill, the 2022 bill envisages setting up of the Data Protection Board. Concept of voluntary undertaking. An entity giving voluntary undertaking can undertake to perform or abstain from certain action, in which case the enforcement proceeding for non-compliance will become unenforceable. Revised scheme for financial penalties. The financial penalties have undergone a substantial change, with the maximum financial penalty up to ₹500 crores in each case. Now comes the question, why is the Digital Personal Data Protection Bill 2022 is important? The reason is, it gives fillip to the Digital India initiatives of the government. Defined legal structure and principles of regulating personal data. Simplifies rules related to data localization and cross-border transfers. Simpler version of previous iterations. No criminal penalty for non-compliances, only monetary penalty, ranging from 10,000 rupees to 250 crore rupees. On July 2017, Ministry of Electronics and Information Technology sets up the Justice Sri Krishna Committee to study issues related to data protection in India. Puthaswamy judgment was passed in August. Sri Krishna Committee report was submitted, along with a draft PDP Bill 2018. Union Cabinet approves the Sri Krishna Committee Draft PDP Bill. PDP 2019 tabled, referred to Joint Parliamentary Committee. After 2 years, JPC report finalized in November 2021. JPC report tabled in December 2021 for discussion. PDP bill withdrawn to bring a comprehensive legal framework aligned with global standards. MeitY releases the Personal Data Protection Bill, 2022 for public consultation, along with an explanatory note. The bill is based on the following principles around the data economy. The first principle is usage of personal data by an organizations for lawful purpose, which is fair and transparent. The second principle is purpose limitation. The personal data is used for the purposes for which it was collected. Data minimization is the third principle. Only those data required for a specific purpose must be collected. The fourth principle of accuracy of personal data is that reasonable effort is made to ensure that the personal data of the individual is accurate and kept up to date. The fifth principle of storage limitation. The storage should be limited to such duration as is necessary for the stated purpose. The sixth principle is that reasonable safeguards are taken to ensure that there is no unauthorized collection or processing of personal data. This is intended to prevent personal data breach. The seventh principle is that the person processing personal data should be accountable for such processing. These principles have been used as the basis for personal data protection laws in various jurisdictions. Personal data means any data about an individual who is identifiable by or in relation to such data. Similar to the previous bill, the new draft law refers to the data subject as the data principal and the data controller as the data fiduciary. Data principal is the individual to whom the personal data relates, and where such individual is a child, includes the parents or lawful guardian of such a child. Data fiduciary is the entity which decides the purpose and means of processing of an individual's personal data. For example, if a person opens a savings account with a bank, then the person is the data principal, and bank will be the data fiduciary. Data processing is consent-centric, but the law introduces the concept of deemed consent. Deemed consent applies to certain situations where businesses can assume that individuals have given consent. This applies in cases where the individual has voluntarily provided data and can be reasonably expected to do so. If you give your phone number to reserve a table at a restaurant, the illustration says that it is fair to assume that the restaurant can call you when seating is available. But will this also mean that you are consenting to receive offers from the restaurant later? Let us know what you think in the comments. Significant data fiduciaries are those who deal with a high volume of personal data. The central government will define who is designated under this category based on a number of factors. They will have to appoint a data protection officer and an independent data auditor. The provisions of this Act shall apply to the processing of digital personal data within India, where such personal data is collected online or where such personal data collected offline is digitized. It also applies to processing of digital personal data outside India, if such processing is in connection with any profiling of or activity of offering goods or services in India. For the purpose of the Act, profiling means any form of processing of personal data that analyzes or predicts aspects concerning the behavior, attributes, or interests of a data principal. The provisions of this bill shall not apply to non-automated processing of personal data, offline personal data processed by an individual for any personal or domestic purpose. Personal data about an individual that is contained in a record that has been in existence for at least 100 years. The personal data will be processed by data fiduciary only for a lawful purpose, for which an individual has given consent, or deemed to have given consent, in limited circumstances, such as medical emergency, for employment purposes, or specified public interest purposes. Consent may be withdrawn at any point of time. A notice must be given before seeking consent. Notice should contain details about the personal data to be collected and the purpose of processing. Data fiduciary must build reasonable security safeguards to prevent data breach, cease to retain personal data, effective mechanism to redress the grievances of data principals. For children below 18 years of age, consent will be provided by the legal guardian. Significant data fiduciaries will have to appoint a data protection officer who will represent them. They will be the point of contact for grievance redressal. An independent data auditor will also be appointed, who shall evaluate compliance with the Act, undertake data protection impact assessment, and periodic audit. Data principals will have 4 rights under the proposed bill to exercise against data fiduciary. These rights are the right to information about personal data and its processing, right to correction and erasure of the personal data collected by the data fiduciary, where the purpose of processing the data is no longer being served, right of grievance redressal with the Data Protection Board, right to nominate an individual who will exercise these rights in the event of death or incapacity of the data principal. Data principals will have certain duties. These are: adhere to all applicable laws requirements. They must not register a false or frivolous complaint with data fiduciary or the board. Not to furnish false particulars or suppress any material information or impersonate another person. Else penalty will be imposed on the data principal. Therefore, provide only verifiable and accurate information. The central government will notify such countries or territories outside India to which a data fiduciary may transfer personal data, provided such countries have an adequate data security environment and the Indian government can access data from those countries. This will ensure that India will be kept connected to the global value chain and collaborate internationally. The bill proposes to set up a Data Protection Board of India as an independent body. The central government will lay down the composition of the board, terms and conditions of appointment and service. The Data Protection Board is the body tasked with enforcement of provisions of this Act. The key functions of board include determining non-compliance and imposing penalties, directing data fiduciaries to take necessary actions in the event of a data breach. In case of an unsatisfactory response from the data fiduciary, the consumers can file a complaint to the Data Protection Board. The bill includes a clear grounds of exemptions from the provisions of the bill, because it is recognized that sometimes the national and public interest is greater than the interest of an individual. Rights of the data principal and obligations of data fiduciaries, except data security, will not apply in specified cases including enforcement of legal rights or claims, performance of any judicial or quasi-judicial function, prevention and investigation of offences. It excludes the collection and processing of personal data of data principals who are not in India by an Indian data fiduciaries. The central government may, by notification, exempt certain activities from the application of provisions of the bill. These include processing by government entities in the interest of the security of the state and public order. Processing of data for research, archiving, or statistical purposes. Exempt certain businesses on the basis of the number of users and the volume of personal data processed by the entity. A financial penalty has been established as the punitive action for non-compliances. The board imposes financial penalty, as specified, not exceeding Rs 500 crore in each case. MindSync has made a complete list of case-wise penalty imposed. Taking into account the new Digital Personal Data Protection Bill, 2022, MindSync gives the following comments on the bill. Narrow focus. The new draft law is certainly leaner, down to 30 sections from 99. It focuses on personal data and excludes non-personal data, which was a demand by the industry. Tackling data localization. The draft law does not require local storage of data. Unlike previous draft versions, it does not ask businesses to store certain sensitive data exclusively in India. But it does not allow free flows of data across borders either. Concept of deemed consent is introduced to cover non-consent-based grounds for processing, which was similar in earlier drafts with certain additions. Relevant information like consent forms, notices, etc., to be prepared in languages recognized under the 8th Schedule of the Indian Constitution. No clarity as to which all countries' businesses can transfer data to. The bill only permits transfers of data to countries which have been whitelisted by the government. But there is no clarity on how the government will whitelist these countries. Data Protection Board is set up only to determine non-compliance and award penalties. It is not set up for setting regulations and standards. The bill has considerably moved away from GDPR, unlike its previous versions. India is charting a path of its own, and it may well be that this becomes a model for many economies. Following the cancellation of the 2021 draft, the current bill was released for public suggestions. Do let us know in the comment box what is your view on the new bill. Stay tuned with MindSync to get all the latest updates. Get in touch with us for all your business compliances. Thank you.